we begin our International Research to Practice Conference on conflict-related sexual violence prevention and response. I'd like to use this opportunity to thank the organizers, Kyiv Taras Shevchenko University, the Institute of Law, and obviously the Department of Criminal Law of the Institute, and our partners, the Global Population Foundation, the Embassy of Great Britain in Ukraine, the Embassy of France, and UA Experts International Organization. Dear colleagues, today is the 627th day of the full-scale invasion. I ask you to pay homage to the memory of all who laid down their lives in a minute of silence.
Дякую. Шановні колеги, перед відкриттям сьогоднішнього
Dear colleagues, before we open today's event, allow me to announce our program opened and to start our international discussion. All the online participants will be able to get simultaneous interpretation. You will see the QR code on your screens and you can join online. So my colleagues will show you the QR code and inform those who need interpretation. The International Research to Practice Conference is announced open.
Дякую. Для модерації сьогоднішнього
Thank
заходу
you. I'll give the floor to the moderator, head of the Department of Criminal Law of Kyiv Shevchenko University, Angela Strazhevska. Thank you. Welcome, everyone. The Department of Criminal Law Policy and Criminal Law of the Kyiv Shevchenko University is highly honored to be a co-organizer of this event. Serhiy Nizhinsky quite rightly said that we've actually lost count of the days since the beginning of the full-scale invasion, and I would like to use this opportunity to say that there can be an alert, and if this happens, we have a shelter, so I urge all of you to go to the shelter timely if that happens. I have to make this announcement. I'm thankful to all those who decided to join our event. I'm happy to see our students here because everything we're going to speak about and discuss today will be used in actual work for you. So we have to make sure that this knowledge is relevant and efficient for you. I'd like to give the floor for welcoming address to the director of our Institute of Law, the Kyiv Taras Shevchenko University, Professor, Doctor of Sciences, Oksana Vasilchenko. Thank you very much. Dear colleagues, dear friends, we're happy to welcome you at our university. I first of all would like to thank our alumni because in your subsequent professional career and in your professional growth, you didn't forget your roots and your alma mater, the Kyiv University. And I'm sure that throughout your life, the knowledge which you will have received here will be very useful, which you will have received here as alumni and as friends of our university. The Kyiv National University, as always, is very responsive to the challenges arising in our country and facing our society. And it's very good that today here and those who have joined online, this audience includes researchers, experts, international specialists in the field which we are going to discuss today. Unfortunately, this topic has become very relevant today for us. And as Angel has just said, we all have to understand what kind of efforts we have to invest to make sure that the mechanism of protecting survivors from sexual violence be effective. We have to exchange our knowledge as regards advocacy practices. We have to analyze the international practices in that and to build our national model thereof. So I wish all of us a very fruitful discussion, and the results which we will have achieved during this conference should be useful for individuals and for the state. Likewise, every success to all of you. Thank you. I'd like to give the floor for a welcoming remark. Unfortunately, that will be online only, but we understand that Ms. Olha Stefanishina is very busy with urgent issues which are on the agenda of Ukraine now. She's a Vice Prime Minister for European and Euro-Atlantic integration. So please show the video address from Ms. Stefanishina. Dear participants of the conference, by joining our efforts together with the civil society and international partners, we have worked out a single mechanism of response of the country to the genocidal actions of Russia. Ukraine has developed its own approaches and practices on the basis of our own very bitter experience. We are multiplying that experience and sharing with other countries. We have shown on our own examples that response to these crimes should not be postponed until the war is ended. We have to resolutely fight for every survivor who requires assistance. We have to hear everyone and to help each and everyone who needs this assistance. This conference today is yet another opportunity to take stock of what has been done, to analyze our steps for the future, and as regards the protection and help to the survivors, I'd like to say that we've launched a network of centers for helping the survivors. There are 11 such centers across Ukraine already, and we are finalizing the first center of this kind abroad. And now we are building our new experience and expertise in cooperation with international partners to improve our service and to make our response to their needs more efficient. The law enforcement bodies and procurators, prosecutors' offices very actively engage with this because they are at the front line of this work. We've put in place all the necessary laws and bylaws that ensure proper standards for work with survivors and witnesses. Over the last year, we've understood that the role of coordination and cooperation of all the relevant stakeholders is absolutely key. It's only by joint efforts that we will be able to help our citizens and to give them the message that we are with them, we hear their voices, and we respond to their requirements, all the way to the judicial processes. Our focus of attention should be placed on assistance, on awareness. We have to stay focused the way we were a year ago, because these crimes do not disappear. Another aspect that I'd like to underline is justice. Each case should be recorded timely, and this is the basis for bringing Russia to account. The voices of the survivors should become the inevitable verdict for the perpetrators, including for the top leadership of the Russian Federation who gave those orders. So our mission is to get this issue across to the world and to make sure that Russia should be brought to full account, and acting together we will be able to overcome all the challenges and to support our citizens, all those who suffered from the violence of Russia in our country. Thank you, and glory to Ukraine. I'd like to give the floor for the welcoming address to the prorector for research and pedagogical work, Andriy Gozhik. Please, the floor is yours, sir. Welcome to everyone. The Vice Prime Minister has already said what should be the focus of our conference. On behalf of the rector, I would like to welcome you, because you are gathered here to discuss very important issues. This is only natural because our university has always been the core of intellectual and research work in our country. And we have to look for and to find responses to actual burning questions.
The issues of sexual violence are not a new phenomenon, and Cro-Magnons and Neanderthals thousands of years ago encountered that. It existed in all the societies, but every society would think of some ways to counter that, to neutralize, to mitigate that. And in our Ukrainian society, for our own purposes, we have some answers for better or worse, but now we're facing a problem that we haven't experienced at least for 75 years. And that is the case when all the internal recipes of fighting sexual violence insufficient, not to our satisfaction. We have to act in several areas. One is external and the other is internal, because you see, we have to provide recipes for the society, for the people who can be victimized or have already fallen victims to that hideous crime. So this is not just fair to punish the guilty parties and prevent recurrence of that in the future, but also to help the victims. I wish the best of luck to your conference, and I believe that those people who have come for answers will get them, and the ones who are supposed to answer will be able to provide. Thank you. Thank you very much. Esteemed colleagues, our next speaker is Mykola Gnatovsky, Judge of the European Court for Human Rights, First Vice President of the Ukrainian Association of International Law, PhD, and Senior Lecturer. He's not in Ukraine. He will address it with a video address, a video call. He's on Zoom with us. Can you hear me on the call? Angela, Madam Director, Mr. Vice Rector, thank you for the opportunity to address you. I'm at work, really. I'm in Strasbourg right now, but I would like to be with you on the premises of my alma mater, our university. At least partially I can accomplish that. And I would like to say that indeed the problem that is being discussed is one of the most acute and from multiple points of view, one of the best suited for evoking responsibility for the guilty parties, and this is about several levels. The level of the immediate perpetrators, the commander's responsibility, those who give orders, those who instigate, those who do not prevent, those who do not take measures to properly prosecute and punish. This is the state's responsibility, sovereign responsibility, as we know, but it is even of more importance to have some issues emphasized by Madam Vice Prime Minister, the support for victims, avoiding the secondary trauma in the process of investigation and prosecution. So it is very important to have the national dimension from the Ukrainian criminal law, from the point of view of the international forum, International Criminal Court, ICC, because this can constitute a war crime and also crime against humanity, and also testify again, provide evidence to establish a crime of genocide. And there's also another aspect, activists, because advocacy is a very important notion indeed, working for correct understanding in the society of the weight of the importance for liability, but also protection of victims. So they are both delicate in their own way. We should not go to the extremes, mind you, because recently, maybe in a smaller scope, but that was would be presented, and sometimes on a bigger scale, in the international arena. Well, we should not confine that to a set of isolated individual acts, and the opposite extreme is overgeneralization. And these are very important and very complicated issues, and I hope that this conference will make another step towards better understanding and better performance for Ukraine and the international fora. So I'd like to greet Taras Shevchenko University on the occasion of this conference. Thanks to all the partners who joined this conference, all the sponsors. Have a fruitful conference, and I wish we meet offline someday. Thank you very much, and have all the best to you. Each time we decide that we will meet offline in one of the classes, and we are leaving the
відеоконференцій.
gradually, but steadily. And I think not much time will elapse when we will be able, not much time elapses when will elapse when we are able to meet in person. And we are now trying to discuss this topic. This is a representative of the ombudsperson, Mihailo Spas. Thank you. I am happy to greet you all, ladies and gentlemen, especially on behalf of the ombudsperson of the parliament, Dmytro Lubinets. It's very difficult to add anything after such honorable speakers, and I would like to thank sponsors and the only thing I can say here that without cooperation, without our attention given to heinous crimes of the Russian Federation which started back in 2014 and are being documented on a daily basis, we won't be able to make all the guilty parties liable and provide all the assistance to the victims that they are eligible for. And every crime has a name, and every victim has a name. And it's our mission. And for you as future leaders of this nation, it is important to work towards the end of naming the culprits and naming the victims, culprits for punishment, victims for support and care. So we have proved that we have the rule of law in this country, and I think that it is only in joint effort, in collaboration, and mutual understanding of what is being done by the Russian Federation in the center of Europe at the beginning of the 21st century will make Europeans support our choice and greet us in the family of European communities. So glory be to Ukraine, and see you in the EU. Well, dear colleagues, I would like to inform you that our video conference is supported with online streaming on Facebook and through Zoom platform. And in YouTube, you will be able to view the conference because it has been recorded at your convenience. You'll be able to view it. So thanks for the greetings, for the good wishes. And now our moderator for the first panel is Alexander Dudorov, Professor, Chair for Criminal Law Policy of the Criminal Law of Taras Shevchenko University, and criminal liability for conflict-related sexual violence according to the international law. That's the name of the panel, and you are here to compare,
recording in progress,
to weigh, to measure all the things that
recording
still have
stopped.
to be done, and to have the idea what should be provided in opposition to the sexual violence. So, Alexander, Professor, the floor is yours. Well, dear colleagues, not all the participants are here. Some still on their way to this room. I have two missions. One is not so honorable, the other is honorable. The not honorable one is timekeeping, and I am there to watch you. I'm here to watch you. We will be listening to 5 speakers on this panel, and they will have to observe the timelines, and the second stage is putting questions. They are top authorities in their respective walks of life. And if you want to make a remark, there is some time allocated. This is 1600 today, the floor discussion. That's the procedure by and large. And my honorable function is to present our distinguished speakers. Our first speaker is Olena Kharitonova, senior lecturer of our chair, our criminal law chair of Koslomoudry National University. And she is also also adjunct of Graz University. She's very well known in terms of gender policy, gender-based violence issues, and she is the one to represent in the Ukrainian Gravia, and that is I'm telling you as an expert in the narrow field, sex delicti, and in 2022-2023 she was publishing a whole set of broad and deep articles dedicated to the problem of criminal justice related to war, and specifically the war of Russia against Ukraine. This is part and parcel, if I'm not mistaken, of their strategy. War can see you, Olena, and hear you. Please, the floor is yours. Good morning, dear colleagues. I would like to express my gratitude to the sponsor, the chair of Taras Shevchenko University for criminal law and criminal policy, and I would like to thank you for your attention, your special attention given to this very sensitive topic that still has to be discussed despite its sensitivity. I hope that you can see my slides. It is very important to have experts in law involved. From the beginning of this invasion, we have one of my colleagues at the beginning of the invasion said this is playing to the hands of the Russian Federation, that law does not matter. Law matters always. And I wanted to refer to Article 38 of UN Charter, the doctrine of engaging the most qualified experts from the nations is an auxiliary instrument for adjudication, prosecution, adjudication. My friend, Professor Dudorov, one said that we had two functions, and the dishonorable one is to observe the rules. I would like to disagree with him. It is a very honorable function. This is all procedural. It should be, because Russia is fighting against all the procedural architecture, security, and legality. So we have to help people, and in that department, it is very important for the community of academics, of advocates, of practitioners of law. Conflict-related sexual violence, forced prostitution, forced pregnancy, forced sterilization, forced abortion, forced marriage, rape, and all the related sexualized tortures, mutilation of female genitals, and also forced nakedness, and this is should be regarded from the point of view of certain criminological characteristics, but Antonio Guterres in 2019 make an address dedicated to the 10th anniversary of mandates for the sexual violence related to conflict. He said that relationship with the conflict can manifest itself through the profile of the perpetrator, because very often these people are related to a certain governmental, non-governmental armed group, and some terrorist organizations can build with this profile of the victim, who is very often is in real terms or in imagination of the perpetrators is part of certain group, has gender identity or sexual orientation, and also this is the environment of impunity that can follow such violence, and certain transboundary consequences that we can often see. This is related to DP status, human trafficking, sexual exploitation, and an armed conflict. Different modalities of existence of sexual violence is related to conflict. I would like to actually touch upon three aspects, because usually in the early literature we find sexual violence as a notion related to the conflict and their modality as an opportunistic manifestation. This means that this war climate provides for several private motives to be expressed in opposing the society, the usual norms, the morality, the law and order, and some rapes are committed because of lust, sexual arousal, but some of them are most malicious to express hatred. Both aspects I would like to emphasize. This is hypermasculinity manifestation. This is fetishing, and this is the norm for that kind of environment artificially created because of the war conflict, the armed conflict. Sexual violence related to conflict as a strategy, and this is because of it being used as the war being weaponized, used for war, and this weaponized sexual violence is quite successful, and it is critical for security considerations, and that puts security in them in the sense like former Yugoslavia and Rwanda, and I will discuss it later.
Міжнародного кримінального суду, оце уявлення про те, що сексуальне насильство є знаряддям війни, стало однією з таких головних.
Sexual violence is one of the instruments of war. What we're talking about here is that this allows people to control the territories which they are trying to capture. This makes it possible for them to intimidate people and to bring down the morale of the opponent, and even to make people flee the territory because of this. Sexual violence can also work as a kind of institutional reward or compensation, like Tamerlane, the Mongolian conqueror, said that the best pleasure in the world is to pursue the enemy and to rape his daughters and wives. So this perception is also about the sexual violence being an instrument of war. And another thing that I'd like to draw your attention to is the sexual violence related to conflict, which is not sanctioned from above as a part of military strategy, but there is a certain leniency of the commanders towards their subordinates for what they do. And very often the different modality of sexual violence practical and otherwise, and can be combined and can be quite possible within a conflict when sexual violence as a practice can result in this opportunism and the expression of this individual motives, and can be strategically useful for the commanders, even when it is not planned as a strategy. So when we speak about the factors of sexual violence related to conflicts, we have to take into account several things. First, individual factors. The thought that the identity of a soldier in the armed forces, well, it is related to some formulas of masculinity, and very often it is kind of depicted as if violence can befit a soldier. And these individual factors are very important because the rank and file soldiers use the situation of the war to express this dark side of their individual character. And another issue which is very important here is the continuum argument, as it is called, that violence during the war is not anything new. This is the structural violence which is a part of the society even outside the war, when women do not have an equal footing with men, be it in government, be it in domestic affairs, when most of the chores lie on their shoulders. And this structural inequality results in gender inequality. And during the war, it manifests itself even more in a more pronounced manner, when women become the first targets of sexual violence. So this is a kind of continuation, like the compressed spring was kept in place, but during the war, it kind of decompresses, and all this results in an explosion of sexual violence related to wars or conflicts. Understanding of this is very important to shape preventive mechanisms. As regards another factor, which I call the group factor, this is about horizontal socialization, when within certain armed groups of combatants, violence is committed, and this is a means of their horizontal cohesion, as it were. It gives them a collective feeling of advantage. And all this results in a situation that they will cover up for each other. And there are commanders who even use these gang rapes to kind of bring up the morale of their subordinates. I also would like to speak about the practice of tribunal in Rwanda and former Yugoslavia, because they created a certain foundation for the response to sexual violence, and genealogy of these tribunals, which you can see reflected on the screen, includes several lines. Maybe this is a broad generalization, but I'd like to dwell upon this anyway. The first line is a Celebic case in Yugoslavia, when the emphasis was placed at the concept of sexual violence, that sexual violence is an act of aggression. You do not have to focus on mechanical aspects of penetration, what penetrates where. The court showed that these cases have a very high level of sensitivity of the discussion of intimate issues. That's why the survivors are very reluctant to give some anatomical details. That's why this is not limited to physical aspects, and it can include actions which are not related to penetration of physical acts. And it's very important that the chamber of the Tribunal focused on this nature of this crime, and qualified this crime as a genocide crime. That was the first time when it was done at such a high level. And Rwanda Tribunal said that the rape was the only way for women to save themselves from mutilation or crippling, which means that sex worked for the extermination of a whole group of people in that area. And this is very relevant to our today's practice. And the Chilevich case was about the Bosnian Serbs, which were held in Chilevich camp and also were victims of rape. As regards the next line, Faluji and Ponorace, those are two cases related to Yugoslavia. There we can see a certain narrowing down of the notion of rape. The court came back to the analysis of mechanics of rape, to the certain anatomic and physical issues, physical acts. But what is key here is that the decision was announced on the 50th anniversary of the Declaration of Human Rights, and the Office of the Prosecutor is paid special attention to this, showing that we are attaching special importance to the issue of a response to sexual violence. As regards the Kunarat's case, there we can see coming back to the argument towards sexual autonomy. The armed serviceman Kunarat and his subordinates engaged in crimes, and two servicemen raped an underage Muslim girl, and then they brought it into a room and told her to sexually satisfy the commander, and she did so. The chamber took into account the fact that she was forced to do this, and she didn't give consent to that. And when the defense tried to use the argument that the commander didn't know that she had not given her consent, but the court said that we have to take into account the general context of the war, and especially vulnerable position of Muslim girls in that context. So we have to take into account the coercive nature of the circumstances. And Hakumbitsi and Mukibana cases are also about Rwanda, and they showed the additional aspects. And in Hakovitsi case, it was ascertained that the defendant encouraged Hutu to kill and rape Tutsi women. And in this case, the Chamber of Appellation said that we should use the instrument of proving the coercive circumstances during which not giving consent is absolutely impossible. And they maintained that the defendant should have known about the circumstances which made consent impossible. As regards the Himan case, this makes a very grim reading, and the chamber said he was guilty in the murder of several Tutsi women, including a pregnant woman, and he
4 хвилинки в мене, да? Чи я?
ripped her belly and took out the fetus,
Ага, зрозуміло.
which
Тоді
was totally
я
horrific.
запитую,
Well, you have to wrap up because time is up. So I will conclude by saying that after the tribunal, the International Criminal Court, in its practice, used those cases. And I'd like to refer to Bamba case where was the first conviction for sexual violence, and there was an acquittal, and the court focused on procedural issues. All the advocates said that this was the payment which was made for sticking to procedure. There was a case of the first conviction for sexual slavery as a crime in line with the criminal law, and in Van case, where was the first sentence for forced marriage. And this case is interesting in that the defendant in his childhood also was
знав все-таки.
child combatant, and that was used as a kind of mitigating circumstance in the conviction. By way of concluding, I'd like to say that very important is to bear in mind the gender sensitivity and the issues of consent, and the understanding that if the evidences of the survivors are credible, you don't have to resort to the analysis of the prior sexual conduct of the survivor. And we can also use other instruments like gender sensitivity and the gender balance in the composition of court chambers, and a number of other procedural issues, which I'm sure will be raised by my colleagues today. So the global dialogue and global communication, when in different jurisdictions, we see different approaches to these procedures. So there is a general recommendation of the Convention for the Liquidation of Discrimination Against Women, recommendation number 35, in which the committee said that gender-based violence as a form of discrimination is being turned today into a principle of international case law, and the participation in agreements is not obligatory today, because this is a part of international case law. Thank you very much, and I hope that during the discussion we will be able to revisit the issues that I had no time to elucidate. Thank you. There will be time for quick Q&A, but now we're running late. And as regards our second speaker, I think that I will start introducing the next partner by saying that we are very grateful to our partners, primarily for the military assistance. But legal issues are not less important. And very important are organizations which are similar to what our next speaker represents. He's, in my understanding, a unique person because he's a kind of combination of two facets. He's a military, even it is written here that he's an ex-commander. He's now in Gaza Strip, and he's also a lawyer. On the side of the organization that he represents, it's written that they support the promotion of legal issues in Ukraine. We will hear his address online.
Good morning. I'm sorry I can't join you in person, but at the moment I'm in Israel. a country also at war today, whose citizens, like Ukrainians, have been victims of sexual violence by their enemy. It is crucial that Ukraine not only acknowledge this atrocity, but also focus efforts on prevention and response to protect the innocent and to ensure justice for the victims. History serves as a powerful teacher, revealing the extent of sexual violence in times of war, from ancient civilizations to modern-day conflicts. This despicable act has plagued humanity, affecting countless individuals. It is imperative that we learn from our past, recognizing the destructive repercussions of sexual violence on individuals, communities, and entire nations. By understanding this dark history, we can strive to break the cycle of violence, not only for ourselves, but for future generations. When it comes to justice for victims of sexual violence in war, we must confront the reality that achieving justice is often a complex and challenging process. In times of conflict, legal systems and institutions may be weakened or non-existent, making it difficult to hold perpetrators accountable. Many victims fear speaking out due to stigma, shame, or potential retribution, forcing their painful experience to remain hidden. However, we must not lose sight of our obligation to provide justice and support for these survivors. Justice for victims of sexual violence in war is not a burden that should be borne solely by the survivors. It is a collective responsibility, one that demands our unwavering commitment to ensuring that the perpetrators are held accountable and the survivors are provided with the support they need to heal. Moreover, it is vital to bolster support systems for survivors, including medical and psychological services, safe shelters, and access to justice. Officially, the Ukraine General Prosecutor's Office has 235 registered victims, including 13 children, but the real number is likely to be 10 times as much, if not more, because victims are often scared to report, do not believe they will receive justice, or perhaps just want to forget about it. On top of that, Ukraine is at present unable to access occupied territories where some of these crimes are happening. The age of victims reported is from 4 to 82 years old, and I understand that around 40% are male. Ukraine should not be left to deal with these horrors alone. The international community must also work to establish comprehensive legal frameworks that explicitly criminalize sexual violence during conflicts. This is one of the responsibilities that an international legal campaign called Payback for Ukraine, with which I am involved, have taken upon themselves. The intention is for civil courts across the world to be working on justice for Ukrainian victims of sexual violence, bringing those Russians responsible for these war crimes to account and providing financial compensation for victims. I believe Jane Alieva is speaking in the next panel and will explain more about the Payback for Ukraine campaign. I wish Ukraine strength and victory in this long and tough battle.
Подякуємо пану Кемпу. Продовжуємо нашу роботу. Я зараз буду надавати слово.
Let's thank our honorable presenter, Colonel Kemp. And I would like to inquire for our next speaker now. Anton Koronevich is not just an expert in international law. He's a practitioner in international relations. He is special envoy and for special tribunal and well, I have read your credentials and I've read through your interviews, and you mentioned once that there are two basic tracks. This is making Russia liable as a state, and this is individual liability for specific persons. And let me just say that today we are discussing project number 1, track number 2, sorry. Thank you, Professor. Thank you, Alexander. It's a great pleasure to be with you today in my alma mater. It is very important to have this ownership. My other place is in Yuri Lenkov Street. That's the Institute for Foreign Relations. It used to be accommodated in this here in the yellow building of the university form, and I'm very happy that I have the opportunity to teach. So it's my institute, and I'm very happy that starting from this year, this school year, we have a special thesis dedicated to regulation of the issue in hand in the international. In a couple of years, I expect it to be a serious work that will serve as an excellent foundation for future exploration of this formidable topic. In the international humanitarian law, this requires some utmost attention. It is hardly that we can find anything to compare with it in the said realm. So we are talking about this thing with our about more than 100,000 cases under 438 of the Criminal Code of Ukraine, and this is a great number and a formidable burden for any kind of system, prosecution, investigation, and our colleagues, of course, are up to this, but we utilize the international partners' support on a large scale. Discussing sexual crime, we should discuss the track of individual criminal liability, individual responsibility for commission of crime, and the issue is what kind of crime and how this can be done. On the one hand, this can be qualified in the part of the special part, and the rape as a grave crime, sexual gratification, and we understand that the Criminal Code of Ukraine, as any other, includes many such crimes, qualified and criminalized. That this is the usual avenue of approach, but it's one thing when we discuss ordinary criminal offenses in the everyday conditions, and it's a different matter when we view it in the light of an armed conflict. So with this international armed conflict, this war waged by Russia against Ukraine, we have to discuss liability for such crimes and the national jurisdiction of Ukraine based on Article 438 of the Criminal Code, which is a blanket, a broad opportunity for our law enforcement officers to feel comfortable in their response to such offenses, investigation, procedural supervision, and so forth. And there is another point explaining why our law enforcement and our prosecutors are focused on this under 438 and less under ordinary general articles of the criminal code. International crimes, war crimes in particular, have no statute of limitation. And when we discuss different types of offenses discussed by Olena before me, and I know that some colleagues will do the same after me, but sexual violence should not be subjected to statute of limitation if it is a war crime. And individual criminal liability for the gravest international crimes, war crimes, should be much more serious than that for the ordinary crimes. So in 2014, 2015, perhaps at a later stage, there are some colleagues investigating this in depth. We can see sexual violence investigated and adjudicated by the Ukrainian courts, but under 438, we have the jurisprudence providing the track for us to proceed because the statute of limitation is not applicable there, and the gravity of the crime matters, of course, and the national jurisdiction. Unfortunately, we have no article on crimes against humanity in any code of Ukraine. We hope that the day will come and we shall enter the family of civilized nations, and then we will have the article on the sexual crimes will get their proper place, and we will receive an instrument for the law enforcement, for the prosecutor's offices to deal, for the prosecution to deal with such crimes. Speaking of international jurisdictions, and coming to individual liability at the international level under article sexual crimes during an armed conflict caused by the Russian aggression. Now we discuss in ICC. First of all, this is the situation when we do not need for proper legal reaction or response. We do not need to reinvent the wheel, because genocide, war crimes, crimes against humanity during this war are all covered by jurisdiction of ICC. This is a great illustration to the situation when we do not have to fill in the gaps. We do not have to create any mechanisms to respond to such crimes, unlike, for example, the crime of aggression or compensation of damage caused and the reparations. These are the two issues where we have obvious gaps. The ICE in the international law. The ICC is based on jurisprudence, case law, first of all, founded by international tribunals for Rwanda and Yugoslavia, and that was discussed by Olena, and international criminal tribunals, both of them, constituted a landmark for the history of international justice. Because in August 1949, the humanity adopted 4 Geneva Conventions for the victims of war. In June 1977, 2 additional protocols appeared. There are 3 now, but we are looking into the first and the second. But before the beginning of the 90s, many people, legalists, lawyers, wouldn't really appreciate the application of those conventions because they had been hardly applicable before appearance of Yugoslavia and Rwanda tribunals, providing that excellent opportunity for the case law to be generated at the end of the 40s and in the 70s. So, the Rwanda and Yugoslavian tribunals dealt with genocide, crimes against humanity, and war crimes, and they turned a very important page, or maybe pages of international justice. Before creation of the two tribunals, in many leading think tanks at many universities, there was that school of thought that only international war conflicts, armed conflicts, could breed war crimes. Now we can see that it is not necessary so, and that provided for further development of the international law and the jurisprudence. ICC is based on the foundation laid and established by the two tribunals on sexual violence, sexual offenses, part of crimes against humanity. This is Article 7 of the Rome Statute. If such sexual offenses are committed against the backdrop of systemic attack against civilians, so the criteria and question of wide scale.
Тут і відповідно Міжнародний кримінальний суд статеве сексуальне насильство воєнними
When we recognize war crimes under Article 8, serious grave violations of international humanitarian law entailing individual criminal liability under the international. What is important, Article 8 of the Rome Statute of ICC criminalizes sexual violence as a war crime in case of international or non-international armed conflict. This is unacceptable under any circumstance. In the Rome Statute and Article 7 and 8, respectively, crimes against humanity and war crimes. This type of violence is incorporated. Another very important point I would like to draw attention to, both in Article 7 and 8, crimes against humanity and war crimes, respectively, the list is open, and any other acts, it says, which are similar to the ones enumerated. And this is very important, especially for the experts and the in the national law. This is violation of the principle of legal certainty by the international law. In sexual violence, sexual crimes, opted for another avenue of prejudice. This is an open list because human nature can generate terrible things. And in 1998, when they were signing the Rome Statute, the closed list, they would have been influencing the jurisdiction. For example, Yugoslavian Tribunal Honorat's case, Olena Kharitonova was referring to that case. There was that sexual crimes, 3 girls were stripped naked, put on the table, and blank point, they had to dance. No penetration, digital or any, but that was a sexual crime in my book. Whether there was any specific language in the Rome Statute, no, and it would be impossible to enumerate or list all the ideas that appear in such heinous situations and such hideous circumstances. So, under Article 7 and 8 of the Rome Statute, the open-end list is a good sign, is a good thing that provides the ICC with the opportunity to decide that certain crimes which are not listed there can also be referred to that category. And if you look on Article 7 and 8, there are no open-end lists. In any other circumstances, crimes against humanity, this is the open list from the point of view of international, it's also a good thing. but all the other lists are exhaustive, and the value of Article 8 of the Rome Statute is that this is the most complete catalog of war crimes presently, but for the crime or category of crime that we're discussing, it's good not to have it closed. Now, speaking of ICC and the fact that ICC can investigate sexual crimes, at least under 2 articles, and there's also genocide, Article 6, where we have accordingly the extermination of the national group, and we can see from Wendian jurisprudence that the gear between positive acts and positive influence is considerable, and we recognize jurisdiction of ICC. They opened their rep office, our prosecutors on cooperation with their prosecutor's office, and we have 2 warrants against Putin and Volodilova, Maria Volodilova, for abduction of children, Ukrainian children, and for us, it's very symbolic that that was the first, that was the most obvious, the most abominable for human mind, but this should be followed by sexual violence, especially with the crimes that are being investigated by the prosecutor's office, and we are expecting some response from the ICC's prosecutor's office. ICC by and large to sexual crimes. The first 2 warrants are good, but we want more because we haven't seen for a long time such a phenomenon, and do not want to see it in the future. So working with the ICC, we can and we should see effective work of prosecution, law enforcement, prosecution, ICC, and the prosecutor's office of ICC to respond to such crimes. Thank you very much, Anton. And the questions will be at the end. I would like to introduce our next speaker. I can see her. That is Katerina Busso, Senior Lecturer Chair of International and European Law, Human Hill Academy. And I have seen many articles penned by her. Cultural heritage, she defended her thesis, but sexual violence related to conflict is also next to her heart because she consults many international institutions, the law enforcement bloc and the legal bloc. Katerina participated in implementation of the international humanitarian law and the legislation of Ukraine. We haven't yet achieved what we hope to achieve, but I have always I'm getting ready for this conference. I listened to her lecture from GFM, and there's this international gender aspect, and from what we've heard, we understand that the issue of combating sexual violence is inseparable from the case law of different practice of different international organizations. Now that Katerina will discuss this about the principal challenges in detection of such crimes stemming from the case law international.
Дякую вам за запрошення і за таке щедре представлення. І дуже прикро, що буду в Києві за кілька тижнів і сьогодні фізично не з вами. Але, звісно, абсолютно з вами думками та, перш за все, роботою на благо України. І в своїй презентації я хотіла би зупинитись на 3 аспектах. Перше – це еволюція договірного регулювання та судової практики, пов'язаної з СНПК, сексуальне насильство пов'язане з конфліктом, та зміни фокусу СНПК виключно навколо жінок та дівчат до ширшої категорії потерпілих, адже це дуже актуально для України. Другим аспектом мого виступу буде аналіз політик превенції та репарації. Знову ж таки, те, що Україна ноу-хау впроваджує не по завершенню збройного конфлікту, а в його ході і доволі вже успішно. І третє, я хотіла би наголосити на 3-му треку відповідальності, з яким я теж працюю, це провадження по універсальній юрисдикції в національних судах, в національних прокуратурах та судах третіх країн, які мають заповнити нішу між перевантаженими правоохоронними органами України та Міжнародним кримінальним судом, який я підтримую пана Антона, сподіваємось, матиме емблематичну справу щодо СНПК, зокрема щодо командної відповідальності, але, звісно, весь спектр злочинів охопити не може, і тому трек універсальної юрисдикції має бути ефективним для України, як ми сподіваємось, що вже є для Сирії та спільноти єзидів. В обох випадках, як ми знаємо, відбувалось дуже сильне сексуальне насильство. Але я почну з першого аспекту, з історичної і, на жаль, хибної асоціації СНПК виключно з жінками і виключно з зґвалтуванням. Перший міжнародний договір, який підписали, насправді, який є діючим і для України, і для Росії, Гаазька конвенція і відповідний додаток про закони та звичаї ведення війни 1899 і оновлений 907 років, я наголошую, який діючий, вважається, що він перший кодифікував заборону сексуального насильства. В статті 46 заборонені будь-які напади, які, зокрема, принижують family honor, як це було написано, тобто сімейну гідність. І ми бачимо, це приклад того, про що говорила пані Олена, коли стаття, яка асоціювалась з СНПК, розглядалась як щось пов'язане з чоловіком, з його власністю, з родинною гідністю. І напад на жінку, зокрема, був заборонений не через її емоційну цінність, її фізичну цінність і недоторканність, а через те, що вона належала певному чоловіку. Женевські конвенції, які ми також знаємо обов'язкові для Росії та України, вперше напряму кодифікують заборону зґвалтування, примусової проституції і те, що називається any other form of indecent assault, інші форми неморальної поведінки, але знову ж таки ця стаття прив'язана до жінок. Окремо є статті і в 3-й, і в 4-й Женевській конвенції, застосовані до військовополонених та цивільного населення, які говорять про заборону нелюдського поводження та катування, і саме ця стаття в практиці згаданих уже трибуналів інтерпретувалась як така, яка забороняє СНПК щодо чоловіків. Але я наголошую, що як до Другої світової війни, так і після неї в договірному регулюванні не було прямого зазначення щодо застосовності і заборони СНПК до чоловіків, хлопчиків та представників ЛГБТ-спільноти. І це насправді є продовженням отих гендерних стереотипів і ригідних гендерних ролей, про які, зокрема, говорила пані Олена Харитонова в своєму виступі. Римський статут Міжнародного кримінального суду, на думку провідних юристок, які сформували практику міжнародних трибуналів щодо СНПК, зокрема, я говорю, наприклад, про канадійку Валерій Устервелд або про американку Патрішія Віжер-Селлерс, яка була першою спеціальною радницею прокурора МКС з питань СНПК і гендеру, вони зазначають, що Римський статут дійсно є найбільш гендерно-сенситивним наразі міжнародним договором. По-перше, перелік СНПК в Римському статуті не є вичерпним. По-друге, лише один злочин, передбачений Римським статутом, примусова вагітність, стосується виключно жінок. Якщо ми подивимось на документ елементи злочину МКС, ми побачимо, що всі інші типи СНПК є те, що називається gender neutral, гендерно-нейтральними. І це дуже важливий посил від укладачів Римського статуту в тому, що, на жаль, СНПК стосуються абсолютно різного спектру людей, чоловіків, жінок, людей, які вважають себе небінарними. І дуже важливо, на цьому наголосив прокурорка на той момент МКС в стратегічних документах, зокрема, в стратегічному документі про обрання та пріоритизацію справ в МКС, також в стратегічному документі щодо сексуального насильства та гендерно обумовленого насильства, що важливо застосовувати взагалі в роботі суду, в розслідуваннях, але особливо щодо СНПК, те, що називається інтерсекціональний підхід, an intersectional approach. Тобто дивитись, як чому злочин був спрямований на відповідну особу, відповідно до її чи його статі, гендерної ідентичності, сексуальної орієнтації, наявності чи відсутності інвалідності, соціального походження, етнічності або раси. І я наведу конкретний приклад щодо України. Якщо ми подивимось на нещодавний дуже великий звіт слідчої комісії ООН щодо України від 23 серпня цього року, ми побачимо, що вони говорять, що СНПК дуже часто вчиняється росіянами щодо бідних категорій населення України, зокрема жінок і літніх жінок, які не могли виїхати з окупованих територій з двох причин: або вони фінансово не могли дозволити екстрену швидку релокацію, або їм треба було залишатись, щоб доглядати своїх родичів, які мають інвалідність або інші обмеження. І тому оця інтерсекція та перетин різних категорій, характеристик потерпілих мають враховуватись як українськими правозахисниками та слідчими органами при документуванні і, звісно, при побудові конкретних проваджень. Щодо певних аспектів справ, які згадували колеги, справа Ntaganda, про яку говорила пані Олена, чому є ще дуже важливою, це перша справа, в якій Міжнародний кримінальний суд сказав, що заборона зґвалтувань не лише в збройному конфлікті, а в мирний час є забороною jus cogens. Це не лише теоретично важливо, це важливо з точки зору практики міжнародного права, адже норми jus cogens мають найвищу силу в міжнародному праві. І це означає, що якщо комусь можна приписати порушення цієї норми, це буде порушення найвищої норми, як порушення заборони геноциду. І вперше Міжнародний кримінальний суд сказав, що зґвалтування як в мирний час, так і під час збройного конфлікту є оцією забороною вищої форми. Дуже важливою також є практика згаданого трибуналу по колишній Югославії в справі Конераца, але я б хотіла покритикувати цей підхід. Чому? Тому що з одного боку в цій справі дійсно було визнано, що обставини, так званий coercive environment, coercive circumstances, як говорив трибунал, вони самі по собі презюмують насильство, презюмують відсутність згоди, але дуже прикро насправді, що взагалі в ситуації збройного конфлікту трибунал дійшов до того, що розглядав питання згоди як таке. Ми бачимо, що насправді Міжнародний кримінал по Руанді мав більш прогресивну позицію щодо СНПК, зокрема в згаданих справах АКЄСу і Мусема, де питання згоди не розглядалось як таке. Ситуація насильства, масових порушень прав людини, а тим паче збройного конфлікту.
In the situations of armed conflicts, this should presume the lack of consent, the absence of consent. As regards prevention and legal justice, simultaneously with the large-scale aggression, and even before that, in 2021, 2020, we spoke about the targeted, sensitive approach to different categories of the survivors, especially to such a stigmatized a group as the survivors of CRSV. Since 2020, Ukraine has been and developing urgent interim reparations. And this is a very important indicator for the survivors and for the international partners, showing that Ukraine takes a look not just at the direction of justice, but also in terms of sensitive assistance, medical assistance, mental assistance, new qualifications, and the possibility of survivors to make their living. This is a very important advocacy and policy message that Ukraine is sending to the survivors and the international community. I know that our colleagues from Eurofan organization, together with a number of MPs and the Office of the Vice Prime Minister, registering draft laws on setting up registers of survivors, those who suffered from the CRSV. And the third aspect that I'd like to focus on, the third vector of responsibility in line with universal jurisdiction in national courts. We know that Germany has investigations of crimes perpetrated in Ukraine. Likewise, other countries, I think 16 in total, investigate such crimes at the national level. And I at least have information about two referrals which were sent to the prosecutor's office of Germany. Both cases are related to sexual violence during the occupation of the Kyiv region, Kyiv Oblast. I was involved in the first reference, Clooney Foundation for Justice. This is also about violence and crimes in Kyiv Oblast. Unfortunately, Ukraine so far does not have a relevant codification of command responsibility for someone who failed to punish their subordinates for the crime. And it is very important that this track the failure to impose this punishment. We do hope that we will be able to redress the wrong, and the prosecutor's office in Germany and other countries will focus on the responsibility of Russian commanders as well, especially as regards CRSV, which should be related not just to girls and women, but also to men. With this, I will conclude. I think a good review of these issues was provided by the UN Commission. I've looked through it too. Latest reviews, reports, and they say that in the unlawful detention places, the prisoners of war, including men, are very often subject to sexual violence. And it is quite likely that in the incarceration facilities, these crimes are more related to men than women, whereas women suffer more often during the occupation of territory. That's why sensitivity in the investigation of these issues is really key. Thank you very much, and I'm looking forward to your questions. We will have questions a bit later. I'll give the floor to Ms. Inna Zavarodko. She is the author of the dissertation on international law entitled Sexual and Gender-Based Violence Related to Conflicts as an International Crime. So probably this is the most focused experts on these issues in Ukraine. In this paper, the author insists that it should be, the formulation should be like this, about gender-based violence. There is a separate part there about the prevention of such crimes during armed conflicts, but that was before the large-scale invasion. She defended the thesis after the start of the invasion. I've seen the feedback on that dissertation, and they say that some of the cases and examples that the author resorted to are absolutely shocking and very disturbing. And one of the opponents said that the large-scale aggression of Russia against Ukraine focused attention on the balance or ratio between the violence as a component of crimes and the general crimes during wars and conflicts. Thank you very much. First of all, thank you for inviting me, and thank you for such attention to my thesis. Well, this introduction kind of changed the focus of my presentation a little bit, because I have to comment on what's been said about my paper. Well, first of all, I'd like to say that apart from being a researcher, which is absolutely important as my social role, I'm also a servicewoman in the armed forces of Ukraine, and serve as a deputy head of the Department of International Law at the Ministry of Defense of Ukraine. That is why, taking part in this event, I will be kind of double-hatted. And the first presentation will be about the dissertation paper, the research that I did therein, and the second one will be about the practical issues which unite the MOD of Ukraine with the issues of investigation of sexual violence and the practical steps which have to be taken to prevent them. So, speaking in my second hat, I can say that it is a pleasure for me to see the cadets of the Military Institute present here, and I hope that they will take in a lot of useful knowledge here, and that you will understand that the period Ukraine is going through now makes it impossible for a serviceman to stand on the sidelines, even if we speak about the issues which might seem like totally unrelated to the military. So, wearing my first hat as the author of that thesis, probably I could carry on for a long time, but I will only comment on what was said about my thesis having been written in 2020. And the defense of that thesis occurred after the 2022. That's why that process was kind of combined. And most of the questions that I received from the opponents were related to the change of policy of Ukraine and law enforcement bodies in the area of investigation and prevention of CRSV and the qualification of Article 438. And a lot of other institutional steps that had been taken by Ukraine and other Ukrainian individual Ukrainian institutions by way of responding to this kind of crimes. Without going into the theory, in my paper, and I keep thinking this way, that sexual violence should include this component, gender-based violence. And Ukraine, unfortunately, is one of the most graphic examples that are proving that this is important. And I will make my case for this later on. It so happened that I'm the final speaker during this panel, so I would like to summarize some of the key issues which we should all remember within the framework of international law.
Було вже зазначено, СНПК може бути кваліфіковане як
It
воєнний
can
злочин.
be qualified as war crime, as crime against humanity or genocide, depending on the context of every crime and on their crime. And we have to look into the circumstances, to the context, and to the words uttered and the general policy of the aggressor country when we take the specific acts of Anton was referring to the Rome Statute of the ICC, providing for this qualification of war crime, crime against humanity, or genocide. So for us, legally, it's an open field, open space. It's a matter of context of the Russian aggression, and also law enforcement and judicial bodies, the national legislation, the most correct. And it's about 20 pages of my dissertation that discuss Article 438 as the most recommended for the acts of sexual violence related to the conflict committed by the Russian military officers in the territory of Ukraine against civilians. So I can dwell on this at length, but this is correct qualification. And as an academic, I'm very happy for Ukraine changing its policy at last, and the law enforcement qualifying everything under 438. This is a correct opportunity stemming from the Criminal Code of Ukraine. The third point I would like to make is this, and that has been when we discuss this matter, we think the sexual conflict-related violence, I can see a lady injured by some Russian soldier, but this is not the only case, and there are many crimes and there are many populations committed subjected to such crimes. When you think about conflict-related sexual violence, you should remember that this is any person in the occupation, regardless of gender or cohort, taken as a prisoner of war, if we talk about military officers, or deprived of liberty if it is a civilian. And so when we bear in mind all the spectrum of the victims, effective and potentials, we can fathom the depth of this problem and the reason why we should address it. Another point that I would like to mention here is that sexual violence is, excuse language, this is a very cheap way of fighting and comfortable for the hideous aggressor. You do not have to manufacture munition, you do not have to flex the muscle of your military industries, and this immediately affects, if committed, not just the person, but the warm circle, the family, and we're going to observe this for a long time, unfortunately. This is not just for an individual, for a family, for a society, but this is for many years to come. This is the opportunity and desire to have family and children in the future. And unfortunately, this is the cheapest and the most comfortable weapon for the Russian Federation, something we have to deal with already and suffer from the consequences in the future. And last but not least, sexual violence, which is conflict-related, is very often used to punish someone or to intimidate to get information divulged. Let's switch to the Ukrainian context. Considering the time that I have, unfortunately, we have this notion of a classical gender-based violence Kiev region, from Kiev to Kherson, we've seen too many of such offenses, and the same time there are 2 acts of sexual and gender-based violence committed, one for a woman, a daughter or a wife, and then the man. And you've heard of the occurrences when in the target of family tried to get some information, potential affiliation of the man with the armed forces, kill him because of this suspicion, and rape this woman. Unfortunately, we have too many of such cases. And this case demonstrates that sexual violence, gender-related violence, gender-based should come together. It's not killing because of the gender, no. Killing women because of gender. Now it's men who are killed because of their gender, because they can fight, they can be mobilized, and that's they are prospects for affiliation of the armed forces. And women are subjected to sexual violence by way of punishment or gratification of some physiological needs because they are women, just because of that. And that is for the territory of Ukraine. One of them has to do with that, and Katerina discussed 2 cases. One of them was committed in the territory of Kiev region. The armed forces of Ukraine, how can they prevent and confront this phenomenon? Is there such a role assigned? So the answer is in the positive, otherwise I wouldn't have appeared here. First of all, military officers, when they are taken prisoners, can become victims in terms of international law, acts of sexual violence, conflict-related, we have to remember about it. And that's why we have active work after they're coming back from war prison to establish such facts. And another related fact is that the armed forces of Ukraine, the leadership, have to take all the necessaries to prevent commission of such acts by our military and defense forces. This is done through the prisms of awareness and information, education for the military officers and the defense sector. This is a very important component, the second one, because we have no such a scale, of course, of the crime, not in the way they have it in the Russian Federation, but we have to prove, we have to advocate, we have to explain why compliance with the international humanitarian law, with the prevention of sexual violence is so important as a component of our defense and our fight. Military officers of Ukraine become first representatives of the state of Ukraine when they deoccupy temporarily occupied territories, they occupy. And so during the armed conflicts, law enforcement and judicial system are not effective, they say, but this is not our case. And this is unique experience when immediately we have helping with the reconstruction, the recovery immediately. So this is the specific feature of our armed conflict. And at the same time, the military officers become first who pose as official representatives of the state of civilians during the occupation of the territories. And after the occupation of the Kiev region, we encountered the issue when the sufferers were sharing their stories with the military, and they were openly admitting that they had become victims of sexual violence in terms of international law, mind you. And what had to be done with that? The issue was so broad and so sensational. You've heard about the sensationalism of this, that we had to take measures, and that's exactly why we developed this practical tool. This is memorandum for sexual violence prevention and banning of sexual violence. This has two objectives. First of all, to raise awareness about CRSV and the action related to it. This is about prevention, and this second part of this set of written rules of behavior, these instructions, this commemorative booklet, they become first representatives of the state, and victims are start sharing cases with them and their own personal stories. And here we have the short list of specific features which have to be done by have to be avoided by the military officers, starting from the psychological aspects, how to communicate properly, avoiding secondary trauma, and how not to collect any material evidence, and even if they are offered. And this is all posted on the sites of the Ministry of Defense, under the rubric of international humanitarian law. All the problems happening in the society because of the armed conflict, international armed conflict between the Russian Federation and Ukraine, in one way or another, are related to the armed forces of Ukraine. And that is exactly why the armed forces of Ukraine, the Ministry of Defense of Ukraine in particular, cannot stay aside, and they have take all the necessary established by the measures established by the law according to the established procedure. And thank you for the opportunity to give this intensive and expedited speech. I am right on time. Thank you very much for being that fast. And it has been an excellent exhibition of your skills, and as a presenter and knowledgeability as a practitioner. I've seen that the cadets have been taking notes. You're the first to evoke such enthusiasm. Now we have 20 minutes for the Q&A session, and I'm sure that they will put questions. People in the audience here, in this audience, will be able to put questions. Then you should have to present your relations. Snezhana, our facilitator. So I feel secure with her around. I'm Snezhana Kush. I am Chief National Coordinator from the Experts Response and Prevention Project, prevention and response, detection of sexual offenses. Our experts provide advocacy and support, raising awareness, maintaining communications, conflict-related sexual violence, and our experts participate in lawmaking, drafting amendments to the effective legislation, and for detecting, documenting, collecting evidence, and by and large response to such offenses. I'm very grateful to our speakers. Inna, tell us, please. We are all aware of the fact that us and our international partners, we know about hideous crimes committed by the Russian Federation. They are soldiers, and we are taking all the necessary measures for response and prevention. But tell us, please, as regards the Ministry of Defense, what kind of measures are being taken? Perhaps some trainings, perhaps some communication activities to prevent CRSV for the armed forces. Thank you for the questions. I can provide information for hours because our Department of Legal Support is responsible for implementation and dissemination and raising awareness as regards IHL. To cut a long story short, as I mentioned during my speech, prevention of CRSV for our forces is done, first and foremost, through raising awareness and educating people about IHL and the duty to observe IHL and specific norms that have to be observed and that protect or have a protective aspect for certain categories of persons under IHL, children, women, specific categories under special protection in both groups. So prevention of commission of psych offenses along with any kind of war crimes is seen through the prism of an education with regard to IHL, and there are plenty of instruments that can be very quick indeed. This kind of card that is the experience during liberation of Kiev Oblast, this commemorative book that serves as an instruction. The component looking to the IHL is integrated into all the system of training and education that we have in the armed forces of Ukraine. And this is the track that we actively use in my department and my team, our team, to having to get all the practical knowledge as much as is humanly possible on IHL, taking all the circumstances into account, valuable for this very category rank and file, and they should not know as much as the commanders are supposed to do in light of commanders' responsibility as a principal. Sergey has a question. One of our sponsors. Good morning, dear colleagues. Thank you for your excellent points. This is a very sensitive subject matter, and I would like to emphasize that this kind of crime has no statute of limitation, and the Department of State of the US included this as one of the most important items for transparency and making public, and so advocates in Ukraine are doing the right thing to actually expose this kind of abuse that Ukrainian population suffer from. What is your opinion and what is your position as academics, as representatives of the state bodies for the military justice draft that has certain difficulties with the pipeline and with adoption, and why law enforcement do not comment on military justice right now, though it is a very timely thing in my opinion. The second principal issue is, well, let me use this example. Our organization expert approached the General Prosecutor's Office under Article 2014 of the Criminal Code of Ukraine to make entries to the single pre-trial investigation register. Interview from a medic taken prisoner of war who announced that there had been hundreds of crimes, but such information has not entered any register, and we are staying at 241 crimes. This is not very correct.
Факти, які внесені до єдиного державного реєстру
And this is not a way to go about it, because the data which comes from investigations by journalists and eyewitnesses are totally different from the number of crimes in the official register. Does this have any impact on the international discourse about that? Because we've basically arrest all the relevant politicians and relevant stakeholders, but the number 241 is not correct the way we understand it, because the number of those crimes are much higher. Even myself, I'm not very much authorized to speak about the issues of military justice. Allow me to respond in general phrases. First of all, thank you for your question. And secondly, my department and the Ministry of Defense were involved in the drafting of the bill on the military justice. And obviously, if we were involved, we support this idea. But as regards commenting additionally why this draft law remains draft, I'm not in a position to do that, morally and officially and otherwise. This is a question to be asked to the MPs. As regards the statistics and the officially registered numbers of crimes, I think this is a question to the Office of Prosecutor General and the relevant directorate. But we all understand, and this is something which has been emphasized by the prosecutor's office, that this is only the tip of the iceberg, that this is not final, obviously, and the register is not exhaustive. The number is going to go up for many reasons. In that respect, Ukraine is not unique, because if you take a look at the armed conflicts which existed before ours, people only after decades start talking sometimes about having been victims of CRSV. So the first problem here is the reluctance of survivors to speak. And in order to bring the culprits to account, we need evidence. Secondly, there are huge Ukrainian territories which are still under Russia's occupation, and we have no physical access to those territories in order to investigate all the cases of CRSV. And once they are liberated, this will be one of the top priorities for our law enforcement and investigation bodies. The third point, which proves that the statistics definitely are not accurate and not exhaustive, is explained by the fact that it's only recently that Ukraine started implementing the policy aimed at the prevention and response to CRSV. You will find very few countries which start doing these institutional things right away. Obviously, all this takes time, both for the survivors and for the state institutions to gather all the evidence, reliable and credible statistics, and to make sure that the survivors are ready to testify. In addition to what's been said, I'd like to say that I'm a strong believer in the fact that we are all here thanks to the armed forces. If it wasn't for them, nothing would have any meaning in what we do and everything. 3 points that I'd like to make. I'm not going to comment on the draft law on military justice, but I'm sure the court procedures if we speak about Article 438 and 432, this is these investigations should not be in military uniform, figuratively speaking. That would be wrong. As regards other draft law proposals, as regards the criminal code of Ukraine and so on, I think those issues are long overdue and should have been done years ago, and now practical issues arise. What do we do? What do we do if these changes take effect as of tomorrow? Will there be an issue of retrospective action of the law and so on? And the third issue, as regards the Office of Prosecutor General, it's really important. Well, obviously, we cannot influence their work, or we cannot speak for them, but the scope of crimes that they're dealing with is totally unprecedented, and obviously all this takes time. There can also be some delimitation of the work burden between the prosecutor's office and the ICC. And sometimes the prosecutor's office is not sufficiently focused on some cases because they expect that they will be dealt with by the ICC. If this is the case, then probably The Hague in the future would be a very important player. Katerina wanted to ask something, please. Yes, briefly, as regards the first question, I do support the reform of the criminal code of Ukraine, because even the existing articles, apart from 438 and the article for the prohibition of propaganda of genocide, is not aligned with the international law as regards public incitement of genocide. We do not have legal criteria to prove that kind of crime. So the first issue, I'd like to say that for me is absolutely key that we should focus on a list of crimes and supplement that with crimes against humanity. And the second point, as regards prevention and reparations, there's an administrative component in that, when survivors should be encouraged to cooperate with investigators and prosecutors, because very often they are not ready to do this right away. But it's key that they are ready to come to the regional bodies through fast-track and simplified procedures, and to declare that they suffered from those crimes. This is not about their inclusion to the criminal procedure, but about should be included in the reparation first. This is an administrative approach which is supported by the Investigatory Commission of the UN, which is very much person-oriented, individual, human-oriented. And I believe that in the notification on the violations and crimes, the survivors should first of all understand that what happened to them is a crime, like forced stripping, for instance. Some people I spoke to said that what was done to them is not as horrible as what happened to other people in their village and so on. That's why they did not feel morally entitled to claim for compensation. And so therefore, this is largely about awareness. We should inform people about what it's all about. Snezhana. Thank you very much. The issue of this is largely the issue of survivors and how ready they are to speak about the crimes. One of the key goals of our projects, and we've held a lot of international events with the participation of local authorities. I have the yellow flower of rape plant, and this flower, with the support of Olga Stefanishina, has been recognized a symbol of supporting the survivors of CRSV. This is a symbol of solidarity with them. This is an invisible gesture that we know about you, we see you, we are ready to hear you out, and if you do so, you will enjoy all the relevant mechanisms for your support. So we work towards simplifying the procedure for certain procedural actions. We will present such flowers to the members of today's panel. When we attend events related to CRSV, we put on this flower as a symbol. So if you go to some international panels, international events, please popularize this national symbol, put on this flower and tell about it. This rapeseed flower, rape flower, is consonant with the word rape as a crime, and this is a symbol which, and there are also closed flowers next to the blooming one, which symbolizes that there are a lot of people who still have not come forward and providing evidence, and we want to support them and ascertain our solidarity with them. The only question I have is how our online audience are going to get such flowers. Well, anyway, dear colleagues, Angela Anatolievna, the head of my department, has a question. I give the floor to her. I will use my prerogative and to ask this question. I thank the panelists for most profound and content-driven presentations. Anton, you put my fears at rest as regards some cases having been undertaken by ICC. I think this is really important. My question, rather deliberations, is about the following. We speak about changes in implementation in the material body of law, but there's also a process. I teach criminal law, and I always lack the knowledge of students in the area of process. And this is absolutely key. And practice and process are two very closely interconnected things. We can imagine what a statute of limitations is all about, but there are also some time frames for pre-trial investigations, and that they are not correlated with the statute of limitations. And like, for instance, today we introduced something into a single register of pre-trial investigations, and there are high odds that after the passage of a certain period of time, the case will be closed because the time frame of pre-trial investigation has been exhausted. So I would like to encourage our legislators to empower us with higher, better quality instruments to better implement relevant provisions of the international humanitarian law, for instance. It should be mentioned that the experience of our law enforcement bodies as regards the investigations of this kind of crimes, our experience and expertise is not sufficient because it's new, and now we're learning as we go along, and we are getting a lot of head bumps in the process. I would like to see that as regards these very sensitive issues, the military crime, war crimes, crimes against humanity, we should have a separate chapter or section in the criminal code of Ukraine, because we have all things imaginable, extradition, international cooperation, or what have you, but there's no notion of continuity of the investigation all the way up to the point when the perpetrators are brought to account and a fair verdict is proclaimed. So this is my point. We have to approach this in a comprehensive manner. Thank you, Angela. Dear colleagues, participants in the conference, with this we have to conclude the first panel. As the moderator, I was worried that something will not work, but everything worked out okay, and I'd like to thank all the panelists for their wonderful presentations, for their input. Those who like to add something, at 4 p.m. we will have a general discussion, and you're welcome to take part. And I also would like to thank the organizers at this point, UA experts, NGO, and to Serhiy and Snezhana in particular. We break off until 12:40. Angela will be moderating. So at 12:40, we continue. Thank you all. Dear guests, in the room next door, through another room, there's a cover served, so please enjoy.
переслідування та відповідальності за сексуальне насильство пов'язане з конфліктом за законодавством України.
The responsibility under the legislation of Ukraine. On the first panel, we discussed the issue of international law and problems of implementation. We have successes, achievements in the national legislation, but for us, citizens of Ukraine living on this soil, the most challenging and formidable is the issue of regulating such process under our national legislation. In fact, before we start this panel, I would like to say that on the first panel, we said that in 1949, the Geneva Conventions had been adopted, and in 1977, the 3 protocols were added, but people are drafting the norms, counting on a certain level of intellectual development in the societies. Unfortunately, and very unfortunately, we have the situation when perception and appreciation of such norms should be viewed through the prism of national cultures and international acts are issued for the global audience, for their appreciation and understanding, but unfortunately, not all the audience is developed enough to appreciate, to accept. Regardless of the situation we're discussing here, we had that great experience in 2014 when we for the first encountered that problem of what had to be done, the president, because he had fled, and with the legislation, the constitution, we had seemingly no way out of that, and we were making up some legal regime or mode. In the same way, we are now dealing with international criminal law, IHL, and the national law. So we would like to start. I would like to introduce our speakers for the second panel. We have Микола Пашковский from R&D Institute, named after the academician Stashis of National Academy of Legal Science, PhD, senior lecturer, advocate Konstantin Zadoya, professor of our chair, our hosting chair, expert in international law, IHL, and well, he is one of the favorite lecturers within not just students, but also members of faculty, and we learn a lot from him. Sometimes we are really caught by surprise. And Victoria Mozhova, I cannot see her, she's online. So joining us online, national consultant of the UN World Population Fund, and you cannot see the topics on the agenda because we have some creativity speakers the free will pick up specific topics under the auspices of a general theme. And in the same way as my predecessor, Alexander, I am going to be your careful timekeeper. And this panel is a bit short in time. And we will get answers, hopefully, from our speakers. First of all, let me thank our defenders for the opportunity to discuss issues related to this panel, to thank our esteemed sponsors for the opportunity to present here, and my predecessors who laid the necessary ground work for my discussion of sexual violence related to armed conflicts and the crimes committed under such circumstances. Well, we are discussing challenges of criminal investigation and prosecution. So let me dedicate my presentations to the problems which, to my mind, actually present themselves for law enforcement, investigators, judges, adjudicators, and advocates along the lines of criminal liability related to CRSV under the legislation of Ukraine. Well, according to my specialty, I am a researcher in criminal procedure, but I joined IHL and ICL fields at some time ago, and national legislation, application of the international one from the point of view of international plan, and how the national legislation can influence development of the international one. So speaking of the challenges of criminal prosecution related to CRSV, I can outline two groups of challenges. General problems related to prosecution of any kind of crime related to an armed conflict, war crimes, crimes against humanity, though we have no notion of that in the legislation of Ukraine, genocide, and specific problems having to do with the prosecution of CRSV. Well, now discussing general problems of criminal prosecutions during an armed conflict, crimes related to an armed conflict, I can discern the following set. First of all, those are problems related to quality of criminal legislation. I think Konstantin will discuss that. Professor Zadoya, the criminal legislation of Ukraine, the part having to do with armed conflicts, international legislation do not match in ICL and its state of development, and there are certain complications stemming from that. You know that Article 438, criminal liability for violation of customs and rules of war. There are 7 forms of the objective side, and one of the most the broadest has the blanket character and refers to the international law, MHL, and it is very difficult to prosecute and adjudicate because there's this necessity to approach international humanitarian law in terms of its essence. Anton was discussing that, and he said that it was even too late, a bit late with the reform of the criminal code and the part of international crimes. Well, another problem is related, which is the broader, and it has to do with the older national mechanism of criminal liability for international crimes. This is legitimacy of the mechanism in question that was discussed in February and March 2022. The capacity of the national jurisdiction of Ukraine, having in mind the set of and the legislation, the national law enforcement and judicial bodies' capacity to prosecute, investigate, adjudicate, and punish people guilty of international crimes, and that includes sexual violence in armed conflicts. And this pertains to several problems. Prosecution is a matter in the conditions of an armed conflict, unlike any previous armed conflicts where crimes would be prosecuted, the Second World War, even the Yugoslavian armed conflict, and Rwandan conflict. We have to investigate not after the conflict, but during the conflict for the first time. And the conflict here is in its prime. And there's another problem cropping up. All the arms and all the parties to the process, to the procedure, are imminently affected by the conflict. I mean, investigation, prosecution, and the judges, and this is true for many specific features of the criminal procedure. The efficiency of this procedure is, in fact, affected by the lack of good methodology for investigation, prosecution, technical support, and knowledgeability, expertise of the parties. And professional parties had to deal with not just the armed conflict, but some expectations of the general public to immediately respond, for the law enforcement and judicial system to prosecution to be able to immediately respond and punish. And we have these requests asking why so many cases are not adjudicated, and we have just a handful ones being actually adjudicated. These are social expectations, and the question is why they are so reluctant to accept the cases, and this leads to a certain backlash, and that can affect and turn the quality of adjudication. And we have already discussed the great number, outstanding number of the incidents where customs and rules of law under 214 would be violated and entered into the register. I visited the site of the General Prosecutor's 120,000 incidents under the Criminal Code of Ukraine and Article 138, and this affects the legitimacy of the system.
Системи, вона обумовлена також надзвичайно великим обсягом доказів, зокрема електронних цифрових доказів, відкритих цифрових даних, які збираються під час цього.
And this is affected by a great number of digital evidence and other pieces of evidence, and the investigators and prosecutors have to analyze, to assess, and provide their opinion during the procedure. And with the War Department or the General Prosecutor's Office, we can see that And this is done for the artificial intelligence with the prejudice and accessibility for the arm of defense.
Дотримання принципу рівності зброї з точки
So
зору
that is about adherence to Article 6 of the Convention for the Protection of Human Rights and fundamental liberties. And apart from that, we have certain provisions in the national legislation which indicate to one-sided approach to criminal proceedings. I'm talking about the note to in chapter 9.2 about the criminal code of Ukraine related to cooperation with the ICC, which implements the provision that Ukraine will not cooperate in with the ICC on the basis of its requests as to its responsibility for the actions of the military of Ukraine. I cannot say that the national mechanism is illegitimate. And what I'm trying to say is that there are certain challenges for the international assessment of this mechanism, and the steps which are being taken today are aimed at mitigating the factors which make an impact on the functioning of this mechanism. As regards special factors or special issues related to the prosecution of CRSV, here we can talk about primarily about such a problem as a partiality of bringing to accountability in cases when individuals are prosecuted for committing some ordinary crimes or for the violation of laws and customs of the war, but are not brought to justice to sexually related violence. We've heard today that there's certain statistics about crimes committed during the conflict since 2014 to 2021, and there were no cases of bringing to account for the violation of the laws and customs of the law, primarily in the context of sexually related violence, even though those crimes did take place at that time. Likewise, now when a suspicion is being issued for the violation of customs and laws of war, they can take into account this effect, and an individual will be brought to justice only for inhuman treatment or torture, but without a clear articulation of the sex-related motive as an element which defines the special character of this crime. Therefore, here we are saying that there may be situations when during the criminal proceedings, focus is not being placed on the fact that this crime is sex-related. And this is a problem not just of the national legal mechanism, but this is the one that the ICC encountered at one point in time in the past. And it was the case in one of the first proceedings of the ICC. When gender-based and sexually related crimes were omitted, and people were prosecuted only for the perpetration of war crimes. Another issue which can be encountered as we focus on CRSV is the complexity of proof. Today, we've heard that in certain cases, individual specifics were manifested in the defense of those cases, and especially as regards the notion of consent and the provisions of Rwanda and Yugoslavian provisions were incorporated in the national legislations, but those provisions are absent in our national legislation. Therefore, as we focus on the proceedings on CRSV related to armed conflicts, the prosecutors will have to be guided by the expertise and practice of the former tribunal on Yugoslavia and Rwanda, and to prove why in our legislation we have to somehow substantiate the absence of consent with due regard to the circumstances. And therefore, we have to implement the proper practice into our national legislation in that respect. And the third aspect, which is related to prosecution of CRSV, against the backdrop of this conflict, is the threat of re-victimization of the survivors. Our national code is not tailored to the investigation of crimes in the armed conflicts. Not just the criminal legislation, but also the procedural code both have some loopholes in that. Not only in terms of the absence of certain institutions. The thing is that in the National Procedural Code of Ukraine, there should be certain procedural measures which prevent re-victimization. Recently at Lviv Forum of Criminal Justice, one of the participants suggested that we implement the notion of informed consent for the questioning of the survivors of CRSV, so that the individual would take his or her consent to questioning, and we should implement the internationally envisioned instruments created to prevent re-victimization of the survivors. These individuals should get a prior psychological support. Their participation in the prosecution should be de-victimized. There should be a set of procedural interviews, and only then this evidence could be used in the court of law without summoning those individuals to the courtroom. So all those are kind of problematic issues. And the final point that I'd like to underline, our today's meeting, the whole conference is dedicated to CRSV in the context of the responsibility for three categories of crimes: war crimes, crimes against humanity, and genocide. I'd like to draw your attention to the practice of the Yugoslavian and Rwanda tribunals and the ICC, which envisions instruments like cumulative indictment and the possibility to bring to justice an individual for committing certain gender-based or sexual violence, for the perpetration of 2 or 3 of those crimes, not just for war crimes in line with Article 8 of the Roman statute. And since all those crimes are different in certain nuances, it means that we should deal with the qualification of individual actions with due regard to the context, not just in line with Article 438, but also in line with Article 442. In the practice of the Roman statute, there have been convictions already on the basis of cumulative indictment for the perpetration of the same actions, but with due regard to the context of war crimes and crimes against humanity. There should be a comprehensive, most full legal qualification of actions perpetrated or committed during armed conflicts in order to provide for a general and special prevention and to cover all the conflict with the proper legal response, which would be backed up with just and fair verdicts and with proper moral satisfaction and compensation for the survivors. Thank you. Now I will respond to your presentation. It would be very desirable that if at the level of the national legislation we would decide in what jurisdictions we're going to prosecute the relevant crimes, which crimes should be prosecuted with the use of national means. We have 3 components, 3, 7, and 8. We're talking about military war crimes, crimes against humanity, and so on. But in Article 6 of the statute, which is about genocide, it's obvious that sexual violence is one of the components of the notion of genocide. So when we talk to international experts, they say genocide is very complicated. Well, it is complicated because this is a multifaceted notion, which includes many notions, sub-notions rather. And if we could accumulate the best intellectual expertise of the researchers, legislators, law enforcers, we could develop a certain infrastructure for what should be prosecuted in which jurisdiction and what articles could be used by us for those cases. Because we have adopted the standards of proof, but whether they are workable when we speak about general ordinary crimes, this is a big question. And obviously, changes to the criminal procedural legislation should be introduced. As regards the need to avoid re-victimization of the survivors, this is our task, obviously. And our students, probably it would be up to them to implement them if this is the thing of the future. That's as regards your presentation, Mikola. And now it is my pleasure to give the floor to my colleague, professor of the Department of Criminal Policy and Criminal Law, Konstantin Petrovich.
По-перше, я хотів би подякувати всім, хто долучився до організації цього заходу і колегам.
I would like to thank all those who have joined in, my colleagues at the university and international experts. I think this is an extremely important event. Unfortunately, given the realities in what we all live
те явище, так, якому цей захід присвячений, тому що в моєму
and the
сексуальне насильство з-поміж
things that we are discussing here, we can say that sexually related violence is one of the most horrible crimes at the very top of the list. So obviously, there should be a lot of efforts to be invested to prevent and respond to it at the national and international level. I'd like to focus on our national practice of the prosecution of these crimes, not that much on the practice, but on the specifics on our practice, our prosecution for sexual violence. Since it so happened, as of today, that the lion's share of these crimes are war crimes as regards our country. So I will dwell upon this issue in more detail. I'd like to draw your attention to the fact that our legislation as regards the prevention and response to war crimes in this respect leaves much to be desired. Last week, an interesting piece of news occurred that the government of Germany adopted a draft law whereby, according to German legislation, there should be new types of sexual violence, sexual attacks, sexual slavery, and forced termination of pregnancy. Well, this is totally in line with modern criminal law, which, as it was emphasized by the previous speakers, has taken certain evolution in time. And in 1990s, the international tribunals of Rwanda and Yugoslavia were in a situation when they prosecuted people for what was sexual violence by common sense, but they had to prosecute people for war crimes like torture simply because at that time the international criminal law did not single out sexual crimes like rape or forced prostitution or forced termination of pregnancy as individual crimes. So that happened in 1990, which is a relatively long time ago. And then when the Roman statute came to be, it singled out sexual violence as a separate crime. And Germany is a positive example of how states orient themselves towards modern norms of law, and they adjust their legislation correspondingly. There's the Code of Crime Against International Law, which was adopted some time ago, and it includes a long list of crimes, including sexual violence, and the Germans prolonged and supplemented that list, but there is no exhaustive list of war crimes, nevertheless. And the third point why this piece of news about Germany is important is that in our country, the situation is totally different.
Статтю 438 нашого Кримінального кодексу, яка називається «Порушення
We
законів».
look at 438 or look on it, and some people think it notorious, some think it glorious, but this is about our legal system and its important feature. In that particular article, we can have no mention of sexual violence, forced prostitution, sexual assault, or anything of the kind. Now, when our investigators or prosecutors investigate and prosecute violations of the IHL, have no opportunity, in fact, to prosecute the perpetrators for sexual violence committed in an armed conflict, in the armed conflict. Well, in my opinion, it is not correct to say that there is no such opportunity. Let me illustrate this opportunity with two case studies. Article 138 has this form of crime that is called cruel treatment of POWs or civilian population, members of the civilian population. Tribunals would, we were referring to, would recognize racism as torture, and torture under IHL is the most dangerous form of cruel treatment, and we can investigate and prosecute this kind of crime. It looks fine, but we have to understand that it's been 30 years since that approach was first adopted, and it has been abandoned since. On the other hand, speaking of the rape, cruel treatment under 438 is not that easy, because this is a judgmental notion, and sentencing for some sexual offense, the court has to justify and explain why there is cruel treatment in it. And we have to refer to the case law international tribunals, special tribunals, and this is cast in stone by now, that rape or any other case of sexual violence is a manifestation of cruel treatment or a case of cruel treatment. We should not overstrain ourselves, and there is a case, and here's your cruel treatment. In that case, we have to find some arguments to explain how we embed this jurisprudence into our case law, future case law, mind you. And the last thing I would like to mention in this respect is that when we sentence people for cruel treatment instead of rape, we distort the reality of such crime. As lawyers, we can deal with abstract categories, but there are categories of life, of existence, and we understand that sexual sphere is special and has its category of specific war crimes. Sexual violence is a specific war crimes, and for rape, people should not be sentenced for cruel treatments or degraded treatments or torture. But that makes another thing, coming back to the topic I was referring to, the international criminal law and single out forced prostitution, forced pregnancy, and rape. So there is this opposite trend, trying or aspiring to specify criminalization of such crimes, unlike 438, which has this blurred notion, because rape and forced prostitution, they all fall under cruel treatment without any doubt, and the stigma that is in now imposed is there. But let's say civilians and POWs. 438 discusses only these two categories, but not IHL. So let's take military medics of the armed forces. This is a special category protected by IHL And when they are in under control of the enemy, they should not be treated as POWs. They should be released immediately if they are not needed for medical assistance, immediate, on the spot, and so forth. And the Russian Federation detain our military medic not just for military assistance, but for detention for the sake of them not coming back home. Well, this is violation of IHL. That's what I wanted to say. Medics are not POWs, so Article 438 and the parts discussing the grain deal treatment does not cover that category. But on the other hand, it is concluded, the article, with such a wonderful form as other miscellaneous violations of rules and customs of law under the international legislation ratified by the Parliament of Ukraine. And there in IHL we can find some kind of a provision that prevents sexual violence or criminalizes it in some form. And people who commit that against some medics, we can actually sentence these people for violation of such customs and rules. But IHL, and part of these ratified agreements, covenants, while rape is mentioned in the Geneva Convention, the fourth, or the first and the second additional protocols, but there is no mention of medics. I'm just using it as an example. And if there is a violence against a medic detained by the opposition, we should look into the general norms for POWs, because medics use the same privilege. I can refer to it. And Geneva Convention number 3 reads that we have to treat POWs without degradation, and we have to deal with the vague categories like humanity, humane treatment, and degradation of personal integrity or personal dignity. Well, in closing, let me say that any kind of state that any kind of punishment should be as public and transparent as possible. In my view, it is very bad when the legal riddle appears. In that legal riddle, you can get easily lost if you're not an expert in IHL specifically. And we have to call a spade a spade. In the 80s of last century, one English professor claimed that criminal law had to be based on honest branding. That was the expression, I believe. And here's the clear violation, and we can call it another violation of customs and rules of law. In this case, this is not really correct, and the legal stigma does not apply. And I think my colleagues from the chair would agree that if we replace the article on rape on other miscellaneous violations of the criminal code, that would appear like a piece of nonsense, and we should avoid the same situation for war crimes, I believe. And now coming back to this example from Germany that I used originally is, this is should be very specific because at the end of the day, this is anthropocentric, and we have to understand that Germany is not in any kind of war, and there is no suffering of the population on mass scale, and this has become part and parcel of our everyday life, but and I can only support those colleagues who for the legal purity of the process, national, our honest attitude as regards such sufferers. Thank you, Konstantin, dear colleagues. As usual, when I look on Article 438, on violation of customs and rules of war, it really sounds as a contradictory notion. Lawless laws, war is lawless, and we are trying to find some evidence or some justification. This is not humane. This is not rules, and we have to look into the protocols and with the aggressive action of some party or several parties, no matter how hard we try to set barriers with legislative acts, crude violence is never in compliance with any kind of humane norms. I think we can discuss such issues because it's not just the national legislation. My colleagues, I think, would agree with this statement, but also the international legislation requires, if not critical change, then at least considerate ones, because we have for decades suffered from this. Let me, as a humankind, Victoria Mozgova, National Consultation of UNFPA about these things. This is UNFPA's turf, without any doubt. Thank you very much. Thank you on behalf of our foundation. And in order to illustrate the problem discussed by my predecessor, what we encounter as investigators, prosecutors, when the problem should be solved with legal rebus, and especially violence, sexual violence, when investigators have to substantiate, they have to recite the international conventions, International Convention of the Hague Convention and Geneva Convention, in order to be able to understand how the language, what kind of language is reflected in the indictment. We should specifically think of the Hague Convention, There's of 1948. There's Article 46, sorry, and when that was adopted, and there is a certain formula that would be applied. But if we discuss our national legislation, it is very difficult to explain when we just contemplate this and discuss this article, family dignity, Article 46. When we discuss this, when the issue started developing of legal protection, judicial protection against sexual violence at war, the focus originally was placed on with women and children. So this is about professional dignity of women. The Geneva Convention, which presently of 1949, Article 3 is the same for all those conventions. This is violence against life and person, degrading treatment, and Article 12 of Geneva Convention, the first and the second, 14 of the third convention, that women should be treated with special care with regard to their sex, as it says, and the fourth convention, that they need special protection against any kind of violation of their dignity, and especially with an attempt commission of rape. And Article 147 of Geneva Convention, that is also a repetition of what is contained in the three previous conventions. The grave violation under the Geneva Conventions are interpreted as the ones that need criminal response, criminal legislation. People have to be made liable. And well, this is not about sexual violence. This is not about rape. In the language, we have infliction of big suffering, serious traumas, intentional, that so manipulating with those notion, manipulate those notions. They can refer to the results of international tribunals, case law, international fora, any kind of interpretations official for the convention. We can take interpretation that in 1992 was provided in the memo by the Red Cross. That was December 1992, and there it says that this Article 147 and the language intentional infliction of serious bodily injury obviously encompasses not just rape, but any kind of attempt on dignity of a woman. So what's a woman again? So, you know, in the cases that we have, we have the sexual violence cases for women and children, and we have that, and there's this problem of latency and
latent nature. I will speak about that later. But again, this is a legal sphere for which should be taken into account by the court and the investigators. We should be combined into one, and in the conditions of total unclarity in terms of our criminal code, and to make sure that this verdict stands at the next instance in court. I am not even talking about the Court for Human Rights and so on. This problem has been existing since 2014. For a number of years, this problem remains unresolved. There's been a huge number of international conferences and events, relevant documents have failed to be put in place in Ukraine. Some documents right after the developments of February 2022 on the basis of the draft 2689, there were some documents which totally negated its provisions. So there are a lot of loopholes and issues. But the international law keeps being developed. And in addition to what Konstantin said, we also should mention some other pieces of legislation which were put in place at the international level and which should be used by Ukraine to bridge the gaps which we have in Ukraine. The draft law failed to come to the second to the third reading in the Ukrainian parliament. Efforts are being made, but the efficiency is close to zero. So we can say that there's been a lot of failures here. That's if we speak about legal clarity. Another problem here is not just of material law, but the problem of judicial defense. And apart from the problems of the body of evidence, and we know that sometimes the investigations happen after the war. Now, during the war, we have a problem of gathering evidence on sexual crimes, because this is an issue of witnesses. This is an issue of publicly known cases of sex crimes like gang rapes and so on. Or sometimes there are evidences that an individual was repeatedly engaged in sexual crimes. If this body of evidence is combined, we can say that there is some foundation, but unfortunately, very often it's very difficult to formulate indictment on the basis of the available evidence, because there's a huge problem with our national procedures and national legislation. Very often, they say that there should be also in international standards if we want to prove one crime or another. We're talking about our national courts, and they have a lack of instruments of how to prosecute this kind of crimes. Another problem is the defense of survivors, judicial defense of survivors, and other kinds of defense of survivors and witnesses, especially if we are talking about crimes perpetrated by groups of armed men or armed individuals, in which case it's very important to safeguard the life and health of witnesses. The Institute of Protecting Witnesses in Ukraine now is at the level of back 1990s. And since that time, our relevant laws have actually not been amended for the better. Maybe this is an issue for another discussion, but the problem is really here. Another point is regards the international law is the impossibility to identify the direct perpetrators of crimes, because sometimes the evidence is not sufficient to clearly identify the person. We can identify him or her as an implicated person who was one in the group of perpetrators, but the personal identification is very difficult. Another problem is in the impossibility of serving suspicion to this person, because at this point in time, this individual is not in the scope of accessibility for our law enforcement and judicial processes. How does the international law tackle these issues? The instruments are there, but our criminal code does not have it. The draft laws that I referenced before include those points, but they have not been adopted yet. I'm talking about part 2 of an additional protocol to Geneva Convention. And they speak about responsibility of not just the perpetrator, but also about the responsibility of superiors, including criminal responsibility. If they knew what was going on, they could not possibly not know what was going on, and they failed to take any action to preclude or stop that. And this is not just about the additional protocols to Geneva Conventions. If we take the instructions of our military, point 8 and subpoint 8 and 9, they include the provisions of responsibility of superiors for the actions of their subordinates. The Roman statute is a good example of codification, but Ukraine has not ratified it. Article 28 thereof speaks about that irrespective of different negative attitudes to the Roman statute, nothing stands in the way of our implementing of the codification of international law into our legislation, which has been done by many countries, irrespective of whether they have signed the Roman statute or not. Very often they say that the US and Israel, for instance, failed to sign it. Why should we? Thing is that the code of the US says that according to this chapter, any superior commander who was supposed to know or could know that their subordinates were doing these actions and who failed to take proper actions to prevent those actions should be brought to account. And likewise, in Israel, there are numerous judicial decisions bringing to justice the commanders and superiors for criminal actions of their subordinates. And a final point, sexual violence during the war, unfortunately, is a violence which has been studied only since 2000, since the year 2000 or thereabout. So this body of knowledge is pretty new. But there are bodies of research which use the arguments that if there is a war, sexual violence is inevitable and it will be rife. If there is a war, we have to admit that this exists. But there are even inter-ethnic conflicts. When there were such upswings of sexual violence. So it's not about the character of the conflict, it's about the conduct of the armed groups, those who are engaged in warfare or who help the armed groups during war or conflicts. Those researchers prove that putting more effort in bringing to account the commanders is the most efficient way of preventing future CRSV crimes. And to make sure that the survivors of those crimes feel that they are protected. This is something that we are trying to do and other countries do. There are a lot of concerns, there are a lot of fears and myths around this issue, but the international law is most graphic in this respect. Our problem of war is enormous in its scope, and if in the civilized world these norms do exist, it's only can be called weird that we do not have those norms in the body of our legislation. So it should be addressed. Another problem is sexual violence against men. A month ago, I learned that there was the first review of the Red Cross, which was published in February 2022, about sexual violence against men. As of now, we have not just gaps in our legislation. We have men who suffered from CRSV, but in terms of providing them with services as a survivor, this is something which is almost non-existent. The instruments of providing them with support are very underdeveloped. Maybe the underage survivors are protected, but adults are not. Thank you for your attention. Thank you very much for your interesting presentation. Please be mindful that as regards men who suffered from CRSV, today we've had only women who raised that problem. We should speak about human beings irrespective of their gender and provide for support and assistance to all of the survivors. I do not agree with you, Victoria, that our instruments are protecting the survivors are at the level of 1990s. Throughout the period of independence of Ukraine, Ukraine has not paid sufficient attention to protecting survivors who suffered from any kind of abuse or violence, not just sexual violence, but saying that it is back at the level of 1990 probably would not be correct. We just don't have proper legislation. Procedural legislation is more tilted towards the protection of those who committed crimes, and not enough attention is being paid to the survivors. What I meant is legislation for the protection of participants in criminal proceedings. If they are members of criminal proceedings, there should be an instrument, a body of instruments used for the protection of these individuals, so that these instruments in Ukraine are very in their nascent form, and they should obviously be developed. They are being considered, and proper stakeholders are working on that, but the process is extremely slow. It's not just about sexual crimes, but any other crimes which are being perpetrated during the war in Ukraine now, and where it is absolutely key to protect witnesses. This is something that we are not very efficient in addressing, and this is one of the reasons why the survivors very seldom go to the law enforcement bodies with their evidence. Any more questions? I'd like to put a very sensitive question to the panelists. A lot of our human rights colleagues who are human rights defenders say that we have to depart from the term victim and to switch to terms like survivors or affected individuals. I don't think this is entirely correct. I'd like to hear your take on this, because on the one hand, we understand that if we use the word victim in working with the survivors, we traumatize them, and it can be used as an instrument. But we, as lawyers of international law and criminal law, cannot disregard this word, because there's a convention which directly translates жертва into English as a victim. Well, there's a law on reparations, which is now being debated in the parliament. What's your take on this? Should we switch from the term victim to other terms, or should we insist that it be preserved in our handbooks, textbooks for lawyers, and in our documents? Well, from the perspective of the criminal process is very simple. We are talking about poterpili, which is a individual affected by some crime, and we qualify this as poterpili, which is a person affected. Criminal code does not use the term жертва, victim, but I don't think that the authors of that code thought about about how to avoid the word victim. And this notion is being juxtaposed to victim as someone who has not acquired a certain procedural status. But your view is a bit more profound, whether the very use of the word victim would exacerbate the victimization of the survivor. And obviously that is your point. Well, just like today we switch from the term invalid or individual with limited abilities to some other notions. I find it difficult to answer that question, but in procedural documents, we use the term poterpili, but it's not very much softer than the word жертва, which means victim. Well, what I meant is something even deeper than that, because I believe that there are risks when we start minimizing in our legal documents, in Ministry of Health regulations, and in other official documents. If we minimize the use of the word victim, this will minimize their opportunity to get reparations and compensations for the crime they suffered. So don't you think that the notion, that the absence of the word victim in the legal field will change the view of the international community as regards reparations, compensations, and so on? I'd like to support the colleague. There is a understanding of the procedural status, and there is the notion of the terminology of international law. All the survivors are victims, but not every victim has received a status of the affected individual in one case or another. We should speak about the getting sufficient body of evidence for individuals to change their status.
І буде проблематика плутанини в кримінально-правовій сфері про те, з якого моменту жертва без процесуального статусу переходить вже в процесуальний статус. Тобто дуже легко зараз, коли ми
That
говоримо.
means that it is very easy to say
Well,
that this
very
author
often,
was recognized as a victim in that
there's a
criminal
lot of
procedure.
lack of
There's no
clarity
threat that this can some
regarding that.
companies
I don't think that
eligibility
it
for
will
reparations.
affect
I
the
cannot
issue
see
of
discussing
reparations or
these
compensations.
matters when
When we
we
stand for the position of
protect
our
the
country,
stance of
when
Ukraine,
we
opposition of Ukraine in
speak in the court of
courts,
law, we
in
can
court we
use
can
the
use
word
victim
victim
as a notion
just to emphasize
referring
some
to some
facets
shades
of
of
this
this
problem.
status
But
of this problem, but
legally, the
legally
issue of
it's
poterpili
not just
affected or
used
survivor
for the criminal
is more
status
understandable when we
and
speak about
for the
compensation issues.
compensation. Thank you very much. It's
It's like always
always
with,
that way
with
and with the
legal
lawyers.
experts. If we agree
We can
on
argue
terminology,
about
we'll
the
agree upon
essentials
everything
as
else.
much as we can. And I understand
the
that
time for our
we have
second
concluded
panel has been
second panel,
used. If there are
and
questions, we may
there are no
give
limitations.
this opportunity to the audience. Dejana, please.
Thank you very much. Thanks to the
thank
speakers
the
of this panel.
panelists.
I
It was
have
most
been
interesting
most
to me.
interested of the
Thank
former
you, Konstantin. When I listened to
alumni
you,
that at
I
every
felt an
point
urge to applaud
I
to what you said,
felt that urge
and
to
thinking
start
at last
applauding.
they've started to
And
speak about
the
that, especially
article
the article on which
is now criminalizing that it is against peace,
CRS
security, humanity, and international order. I have
articles
always
are included
regarded this from the
into
point of
the
view of
general
a
body of
victim.
crimes
And
against
even if
humanity,
we have
dignity,
this
and so on.
legal
Even if there is a verdict against one person or another,
legal
will people
conviction
feel that justice
is it
has
about
been done?
justice because we have
The verdict
this
is announced
the name
on behalf
in the
of
name
the
of
state,
Ukraine and the
and
name of
it
the state,
condemns the
but this is
criminal
violation
for
of
the
the
violation of
international law, and there's nothing
law, and
about
nothing is said about
protection
the
of
protection
sexual
of
freedom,
sexual
personal integrity,
dignity and
integrity of
right.
persons.
And you said that in that
And
respect,
I would like to ask you,
legislation
what is your
requires
opinion? Would it be enough for this
additions.
article
Maybe
438,
this article 438 should be
enumeration of
added and
this
supplemented with
acts,
the
criminalization of
perpetration
this
of
requires a
criminal
special
violence. Or maybe it should be a
special article
separate
with some
article with some
qualifying
characters.
elements.
Дякую за питання. Ну, я думаю, що
Well, I think that partially this is a term, is a matter of legal technique or preparedness, let's say, for parliamentarians or lawyers who can live with a certain templates or abandon certain templates, like Victoria discussed with all the colleagues. For that matter, we're discussing this special article, war crimes against person, and there is a special section of sexual offense. This is next to degrading treatment and infliction of serious bodily harms. Well, ideally, in the ideal world, we can choose the path of criminalizing every single offense under separate article. We have already mentioned that the colleagues who are not here, unfortunately, they are working on the draft of the new criminal code, and I'm in on and off communication with them. And you are starting from scratch, I say, so you can be as precise as possible in criminality, sexual violence, and so forth. But they picked another avenue approach, picked in the draft submitted by the cabinet. This is more compact. And they say, cannot think of adding 40 articles. It is too critical that in their shoes I agree with that position and that proposition. Thank you. Any further questions? One more question. Constantine, how about the retroactive action? I think in sexual violence cases, we should not expect any such problems. Basically, when we worked 679, it used to be, I'm not sure about the number, actual number. Now, the prosecution was concerned with the decriminalization. I do not expect such a trap there. 438 now criminalizes not all the violations of the customs and the rules of law, and according to IHL, only grave violations of IHL constitute war crimes. We cannot encompass all the serious crime with 438. This is not very typical for us. The war crimes committed related to an armed conflict, which is not international. There is customary law, customary IHL. Well, now, speaking of war crimes committed in international armed conflicts, in an international armed conflict, there's mentioned in some article or separate article. I do not expect any retrospective effects. Of course, the sanction can be milder in some aspects, but there is no way out, and it can be of priority, especially in the part where it is milder. And we have to be correct in sanctioning that judicially to avoid unnecessarily aggravating sentences. Are there any questions? So should we have some coffee before the third and final panel? No questions. Let's have a break. You're all invited.